Clients have asked, how long do you have to be separated before you file for divorce? And the answer is, you don't have to be separated. You can still be living together, even raising children together when you file for divorce. On the petition for dissolution of marriage, there is a line item to ask, what was your date of separation? And you can put the date that you're signing this document, or you can even put to be determined. Your date of separation can even be sometime after the divorce decree is entered, because the two of you are still living in your house and you're selling the house and waiting to divide the proceeds. So don't worry about any separation time in Colorado before filing for divorce. When couples separate, there's often a question of spousal maintenance, or what is the other spouse entitled to if you're the one who's in possession of the assets or the business or the thing that's worth money. And the answer is, it depends. You need to be at least married for 3 years before spousal maintenance would apply. And then it's going to depend on what was the contribution of each spouse to the marriage, to the assets, or to the debts. It's a very complex question that doesn't have a lot of general default answers to give. If you have any questions about this, it is best to give us a call so we can discuss that further. A question I've heard often is, what is the wife entitled to in the divorce? Because in a traditional sense, it's been the husband who's been the breadwinner and the wife stays home to take care and raise the children. Of course, with gender identity and the evolution of who gets to work in the workforce, it's not just husband or wife. It can be husband, wife or wife, they, them. It doesn't matter. What does matter is that there are two adults who've contributed to the marriage. And upon the divorce, there's a division. So if you've been married for at least 3 years, the spouse who stayed at home to help raise the children in that scenario definitely will be entitled to seek spousal maintenance or alimony. When it comes to who will be the primary parent, the default is that both parents will be the primary parent. Both will have 50-50 parenting time. If there needs to be deviation from there to fit your circumstances, then by all means, let's figure out what that deviation is. I do recommend that you have a divorce lawyer or attorney, even if you have all your assets and debts and your parenting time figured out between the two of you. There is still a lot of paperwork and requirements that the courts expect of you, even if you don't have an attorney. And more often than not, it'll be a huge time saver and money saver if you invest in having an attorney to facilitate the process so that you don't waste your time or end up coming to an agreement that's not enforceable by law. You will save money by hiring an attorney more often than not, because for me, it's my job. I do this every day. So I know what to look for, what forms to fill out. And even in circumstances where couples think that they're in a non-contested matter, that's very infrequently the case. And if you cannot agree, then you are wasting your time and your emotional energy trying to show up in court and appease the judge that your settlement agreement is fair and not unconscionable to both parties. And sometimes, even if you agree to say that the husband will keep the wife on his health insurance, even after the divorce, as part of an exchange of alimony or spousal maintenance, that's not enforceable. And so to save yourself time and money and sweat and tears, it's just better to invest in having an attorney to facilitate everything so everything goes through first time. Colorado is a 50-50 state in divorce. It's 50-50 in two general ways. It's 50-50 when it comes to the division of assets and debts, and it's 50-50 when determining child parenting time. From the 50-50, there can be deviations, but there has to be circumstances to support the judge giving you what you want. So if you need an 80-20 division, there has to be a reason, such as one spouse contributed 80% towards the mortgage and paid the mortgage, and the other party only contributed 20% towards the down payment. In that very general hypothetical situation, that would be a place to start with to say the division of the house should be 80-20. If you have any questions about your divorce, please give us a call at Newly Family for a free case evaluation.